Okay, so hello and welcome to Rebecca Day, our wonderful HR collaborative columnist. Here today we are going to be talking about Salonpreneur magazine, the second edition. I don't actually have it in my hands at the moment, hence it's on my iPad. And this is Rebecca's article that's going to be in the second edition, all about employment law 101 and what you need to know as a salon owner. So we are going to be talking about employment contracts, aren't we? And some of the key things that need to be on there. So give us a breakdown and a little bit of a deeper dive on a couple of the bigger areas. One of the things I wanted to cover actually was about the vicinity when people leave.
Yes.
That's something I'd like to cover because that's a big problem that I see people having stress over a lot. But if we just sort of like break down immediately why we need contracts, what we need to do about them, how we need to prepare them, who should prepare them, and how we enforce them.
Right. Well, nice to see you.
See you again.
So what I'm doing over the next few editions is really breaking down employment law for salon owners, the pitfalls, what you need to know, really simplified language. And of course, the starting point is getting your contracts right. Really important because it governs the whole employee relationship. You don't want any grey areas. You know, it's only reasonable to let your employees know what they need to do and also in return what you're going to do for them. There's a couple of things, there's some points that you have to have in there. Obviously, you have to confirm job title, working hours, and really make sure those are very specific. What holidays people get, sickness arrangements. You have to give details of what somebody needs to do if they need to take a disciplinary, they want to raise a disciplinary or they have a grievance. But I would say always go further than the bare minimums. Think about the things that you need in place to protect your salon, like confidentiality clauses, data privacy, and the point that you mentioned, radius clauses. Now, I wish I had £1 for every time somebody tried to enforce or contacted me to try and enforce a radius clause. So what's a radius clause? It means if somebody leaves you, you want to obviously make sure they're not going to set up shop next door, poach your clients, what have you. But then I see ridiculous things like, you can't set up in a salon or work for yourself within 5 miles of my salon.
It's ridiculous.
And that's, I mean, it's completely against, the competition law. Rule of thumb, the maximum you can get away with ordinarily is 6 months and half a mile within the vicinity of your salon. Any more than that, and a court's going to say it's not enforceable. The big point as well is that by some time somebody leaves you, they're actually not an employee. So it's not an employment tribunal. You would have to take them
It's
to
a civil case.
civil case, and that's expensive.
Yeah.
And it's more expensive if you lose. So be really, really careful about that. Really carve out in the contract about non-solicitation of clients as well, and things like you shouldn't be, if somebody's resigned, they shouldn't be telling their clients, where they're going to, and encourage them to move on.
Yeah.
Clients are the salon's clients.
And this is a really odd one, isn't it? Because we don't own anybody technically, but I think probably GDPR helps the owner here, because the data is owned by the salon.
Exactly.
And I think and like now with booking systems, and I see this an awful lot. And I know if anybody ever left my service, one of the first things I do is remove them from the booking system so that they can't access that information. Because they have no rights to it any longer, because they're no longer an employee and should no longer have access to that client's data.
Absolutely. And it's also, if you're processing a client's data, it should be for legitimate purposes only. Quite clearly, downloading clients' information without their permission so that you can then go and contact them about setting up shop elsewhere is just a no-no. So
it is a breach of the Data Protection Act, and it can be enforced by the Information Commissioner's Office.
It can indeed. You do not want to be dealing with a subject access request from a client. You don't want to be dealing one from an employee either. But yeah, the client has the right to find out, what information you're holding on them and how you store and process their data. Other big one is social media. You know, really make sure that you've got a proper social media contract in place. So against what people can post and what they can't post. You know, people think, you know, it's Facebook, it's Insta, I can post whatever I like. It does have, if it has implications on the business, then, you know, you be within your rights to investigate that. So make sure people really understand what they can say and can't say and what they're allowed to post in terms of, you know, client images.
Yeah. And because I was going to say as well, but that is another place, because although that isn't held, that information isn't held obviously within a booking system, there is client data there, isn't there? Because clients are going to be on the Facebook page, clients are going to like and comment and do all those things, and can be approached by third parties in that way, and ex-employees or even other competitive businesses can do that. But that also would fall within potential GDPR, wouldn't it? I would have thought, I think. Or is it open? Is it open game then?
I think it's, you know, I think what you can do as a business owner is to protect yourself and just say,
Mm,
you know, in terms of how they should be interacting with clients. I think that's fair enough.
mm,
That you can, obviously you wouldn't say derogatory, but you know, non-solicitation of clients also includes
yeah,
not approaching them on any kind of social media in order to
yeah,
potentially poach them. One thing I really did want to reinforce to anyone listening today is that contracts are only as good as how you enforce them. Because if, for example, you've got in somebody's contract that they're working, I don't know, 9 till 5 each day,
yeah,
but in custom and practice, they're only working 5 days, 5 hours a day, you know, 10 to what have you, and it doesn't reflect what's in the written contract. Over a period of time, what they're doing in practice overrides what's in the
yeah,
contract. A lot of people fall foul of that.
yeah.
Have your contract, make sure it continues to reflect how someone's working. If not, consult with that employee and refine it. That's so important.
And can I ask as well, because now I've actually used custom practice. I ended up on a staff side consultation with a huge
I think
PLC many, many years ago, wherein we actually won a huge amount of holiday payback because somebody had allowed us by custom and practice to have, as part-timers, 20 days leave a year when we should have only had 10. But they, no, you've got 20 days. And we're like, are you sure this shouldn't be prorated? But we had that for 2 years. So when it came to redundancy, they had, because customer practice was in form, even though our contract stated 20 days, or I think the contract did state 20 days, and we'd asked to have it corrected because two of us were ex-HR people. And they said, no, it's fine. But of course, they ended up coming unstuck because they tried to change it at the point of redundancy. So that was one thing. So customer practice is a really, really important thing to remember as an employee and as an employer.
absolutely,
Yeah. And
absolutely.
the other thing that I wanted to bring in here very quickly, because I know we're on limited time today, is when you say 9 to 5, what happens is an employer allowed to say you need to be in at 8:45 to set up for 9 o'clock clients? Because you also see this a lot. And
It's,
I know my friend who works in education, totally separate to our industry, has this exact thing, and she's expected to be there 15 minutes before to get ready.
I mean, you could, you know, I think it's what's reasonable. Often you'll see 5 minutes and you'll see 15 minutes. I always say you need to arrive so that you are ready to work, having had a coffee, been to the loo, what have
Yeah,
you, so that you're ready to start at 9 o'clock in the
yeah,
morning, 10 o'clock in the morning. I think that's more reasonable.
yeah,
You're mandating that someone's coming in, just my personal perspective, if you're mandating that they're coming in early, 15 minutes or so, it really should be paid, you
yeah.
know.
And
But
also that clear up at the end of the day, because obviously that falls, clients will be booked through till 5, but then you've got the clear down and put the
that's
washing on
part
and
of
do.
your duties and you should be paid for it. But
Yeah,
yeah, I think that's the way to get around it. You need to be there, ready to work, ready for the day to greet your first client at 9 o'clock, 10
yeah,
o'clock. Yeah.
yeah. Wonderful. I know, because these are all little things that you just see
Yeah,
all the
in our
time.
industry.
That I know I always paid my staff when I had employed staff, I always paid them 8:45 to 5:15 because
Yeah,
yeah, because they're still working for me. Just because they're not working on a client and bringing money in,
yeah,
that should be factored into your pricing, shouldn't it, at the end of the day?
absolutely,
Yeah.
absolutely.
But anyway, I think we need to finish up. We've had a very brief conversation today. But is there anything else that you want to add about contracts that you think would be helpful?
Yeah, just make sure that you get the proper contract done.
Yeah.
If you're going to spend any money at all, get a good contract written up.
Yeah.
Don't go to an accountant. Don't borrow somebody else's as a template. You need to have a contract which is specifically written for
Yeah.
your business. And a salon, if you're an HR consultant, will sit down with a salon owner and say what's important to you.
Yeah. And I think as well, isn't it, is that, I mean, especially now with the wonders of AI, is that technically you could go onto any AI platform and say, draft me up a contract that says X, Y, and Z. But it's going to miss all those nuances because it isn't a HR consultant as much as it can act as an HR consultant.
It will bring up a whole load of stuff. I've tried it because I was interested.
I'm sure you have.
It can bring up a whole load of stuff, but it's not infallible. And you really need to ensure that you can fact check it. And that's the problem.
Yeah.
If you don't know, you won't know how to fact check.
No.
So yeah, I would just be very careful of that.
Absolutely. So we'll leave that there for today, and I'll be chatting again with you next quarter. And so thanks ever so much, Rebecca, for coming on, and I'll speak to you soon.
Speak to you soon.